Corporate powers. General powers. A. Sue and be sued in its corporate name. B. Succession. C. Adopt and use a corporate seal. D. Amend its articles of incorporation. E. Adopt and amend bylaws. F. For stock corporations, issue or sell stocks to subscribers and sell treasury stocks. For a non-stock corporation, admit members to the corporation. G. Purchase, receive, take or grant, hold, convey, sell, lease, pledge, mortgage. Otherwise, deal with such real and personal property pursuant to its lawful business. H. Enter into merger or consolidation with other corporations as provided in the code. I. Make reasonable donations, including those for the public welfare or for hospital, charitable, cultural, scientific, civic, or similar purposes, provided no corporation, domestic or foreign, shall give donation in aid of any political party or candidate, or for purposes of partisan political activity. J. Establish pension, retirement, and other plans for the benefit of its directors, trustees, officers, and employees. And K. Exercise such other powers as may be essential or necessary to carry out its purposes. Note, the corporation has implied powers which are deemed to exist because of the following provisions, except such as are necessary or incidental to the exercise of the powers so conferred. B. Such powers as are essential or necessary to carry out its purpose or purposes as stated in the Articles of Incorporation. That's a catch-all phrase. Specific powers. Power to extend or shorten corporate terms. Power to increase or decrease capital stock or incur, create, increase bonded indebtedness. Power to deny preemptive rights. Power to sell or dispose of corporate assets. Power to acquire own shares. Power to invest corporate funds in another corporation or business. Power to declare dividends. Power to enter into management contract. Power to extend or shorten the corporate term must be approved by majority vote of the Board of Directors or the BOT. Ratified at a meeting by shareholders representing 2/3 of the outstanding capital stock or 2/3 of members of a non-stock corporation. Written notice of meeting includes proposed action, time, and place of meeting shall be addressed to each shareholders or members at his place of residence and deposited to the addressee in the post office or served personally. Appraisal right may be exercised by the dissenting stockholder for both extension and shortening of corporate term. Now, the power to increase or decrease capital stock or incur, create, increase bonded indebtedness under Section 38, same requirements above from 1 to 3. And then, a certificate in duplicate must be signed by a majority of the directors of the corporation, countersigned by the chairman and the secretary of the shareholders meeting, setting forth 1. That requirements of this section have been complied with, the amount of the increase or diminution of capital stock. In case of increase, the amount of capital stock or number of shares of no par stock actually subscribed, names, nationalities, and residence of the person subscribing, the amount of no par stock subscribed by each, the amount paid by each on his subscription, or the amount of capital stock or number of shares of no par stock allotted to each stockholder if such increase is for the purpose of making effective stock dividend. Any bonded indebtedness to be incurred, created, or increased, the actual indebtedness of the corporation on the day of the meeting, the amount of stock represented at the meeting, the vote authorizing the increase or diminution of the capital stock, or the incurring, creating, or increasing of any bonded indebtedness. Prior approval of SEC is required. Duplicate certificates shall be kept on file in the office of the corporation, and the other shall be filed with the SEC, attached in the original Articles of Incorporation. From and after approval of the SEC of its certificate of filing, the capital stock shall stand increased or decreased, any the incurring, creating, or increasing of any bonded indebtedness authorized. SEC shall not accept for filing any certificate of increase unless accompanied by the sworn statement of the treasurer of the corporation showing that at least 25% of such increased capital stock have been subscribed and that at least 25% of the amount subscribed has been paid or that there has been transferred to the corporation property the value of which is equivalent to 25% of the subscription. SEC shall not approve any decrease in the capital stock if its effect shall prejudice the right of the corporate creditors. Bonds issued by a corporation shall be registered with the SEC. The power to deny preemptive rights. General rule: all shareholders of a stock corporation have the preemptive right to subscribe to all issues or disposition of shares of any class in proportion to their respective shareholdings. Exception: if such right is denied by the Articles of Incorporation or an amendment thereto. Preemptive right shall not extend to 1. Shares to be issued in compliance with laws requiring stock offering or minimum stock ownership by the public. Shares to be issued in good faith with the approval of 2/3 of the stockholders representing outstanding capital stock in exchange for property needed for corporate purposes or in payment of a previously contracted debt. Note: for closed corporations, the preemptive rights extend to all stock to be issued, including reissuance of treasury shares, whether for money, property, or personal services, or in payment of corporate debts, unless the Articles of Incorporation provides otherwise. Power to sell or dispose of substantially all its assets. Same requirements from 1 to 3 as Section 37 above. Any dissenting shareholders may exercise his appraisal right, deemed to cover substantially all the corporate property and assets. A sale or other disposition shall be deemed to cover substantially all the corporate property and assets if thereby the corporation would be rendered incapable of continuing the business or accomplishing the purpose for which it was organized. After authorization by the shareholders or members, the BOD or BOT may abandon such sale, lease, exchange, mortgage, pledge, or other disposition subject to the rights of third parties under any contract relating thereto, without further action or approval by the shareholders or members. Corporation is not restricted in its power to sell or dispose of its assets without the authorization of shareholders or members, if the same is necessary in the usual and regular course of business of the corporation, or if the proceeds of the sale will be appropriated for the conduct of its remaining business. In enumeration number 5 above, only the approval of a quorum of the BOD or BOT is required. While the Corporation Code allows the transfer of all or substantially all the properties and assets of a corporation, the transfer should not prejudice the creditors of the assigner. The only way the transfer can proceed without prejudice to the creditors is to hold the assignee liable for the obligations of the assigner. The acquisition by the assignee of all or substantially all of the assets of the assigner necessarily includes the assumption of the assigner's liabilities, unless the creditors who did not consent to the transfer choose to rescind the transfer on the ground of fraud. To allow an assigner to transfer all its business, properties, and assets without the consent of its creditor and without requiring the assignee to assume the assigner's obligations will defraud the creditors. The assignment will place the assigner's asset beyond the reach of its creditors. Power to acquire its own shares. For a legitimate corporate purpose or purposes including but not limited to the following: to eliminate fractional shares arising out of stock dividends, to collect or compromise an indebtedness to the corporation arising out of unpaid subscription in a delinquency sale, and to purchase delinquent shares sold during said sale, to pay dissenting or withdrawing stockholders, provided there are unrestricted retained earnings in the corporate books to cover the shares purchased or acquired. Power to invest corporate funds in another corporation or business. Same requirements from 1 to 3 as Section 37. Any dissenting shareholder shall appraisal right, where the investment is reasonably necessary to accomplish the corporation's primary purpose. The approval of the shareholders or members is not necessary. Note, if it is for the same purpose or incidental or related to its primary purpose, the board can invest the corporate fund without the consent of the stockholders. No appraisal right. If the investment is in another corporation of different business or purpose, but in pursuance of the secondary purpose, the affirmative vote of the majority of the board consented by the stockholders member is required. If the investment is outside the purpose or purposes for which the corporation was organized, articles of incorporation must be amended first, otherwise it will be an extravious act. A private corporation, in order to accomplish its purpose as stated in its articles of incorporation and subject to the limitations imposed by the corporation law, has the power to acquire, hold, mortgage, pledge, or dispose of shares, bonds, securities, and other evidence of indebtedness of any domestic or foreign corporation. Such act, if done in pursuance of the corporate purpose, does not need the approval of the stockholders, but when the purchase of shares of another corporation is done solely for investment and not to accomplish the purpose of its incorporation, the vote of approval of the stockholders is necessary. Power to declare dividends. Out of unrestricted retained earnings, payable in cash, in property, or in stock to all shareholders on the basis of outstanding stock held by them. Any cash dividends due on delinquent stock shall first be applied to the unpaid balance on the subscription plus costs and expenses. Stock dividends shall be withheld from the delinquent stockholder until his unpaid subscription is fully paid. Should be approved by 2/3 of the shareholders representing the outstanding capital stock at a regular special meeting called for that purpose. Stock corporations prohibited from retaining surplus profits in excess of 100% of their paid-in capital stock, except when justified by definite corporate expansion project or programs approved by the BOD, when the corporation is prohibited under any loan agreement with any financial institution or creditor from declaring dividends without its consent, and such consent has not yet been secured. When it can be clearly shown that such retention is necessary under special circumstances obtaining in the corporations, stock dividends cannot be issued to a person who is not a stockholder in payment of services rendered. A corporation may legally issue shares of stock in consideration of services rendered to it by a person not a stockholder or in payment of its indebtedness. A share of stock issued to pay for services rendered is equivalent to a stock issued in exchange of property, because services is equivalent to property. It is the shares of stock that are originally issued by the corporation and forming part of the capital that can be exchanged for cash or services rendered, or property. A share of stock coming from stock dividends declared cannot be issued to one who is not a stockholder of a corporation. Cash dividends versus stock dividends. For cash dividends, voting requirements for issuance, board of directors only. For stock dividends, board of directors plus 2/3 of the overall capital stock. Effect on delinquent stock under cash dividends shall be applied to the unpaid balance on the subscription plus costs and expenses. On stock dividends shall be withheld from the delinquent stockholder until his unpaid subscription is paid. Can this be issued by executive committee? On cash dividends? No. How about on stock dividends? No, since this requires stockholders' approval, Section 35. Power to enter into management contracts should be approved by the BOD and by shareholders owning at least the majority of the outstanding capital stock or at least a majority of the members of both the managing and the managed corporation at a meeting duly called for that purpose. Should be approved by the 2/3 of stockholders owning outstanding capital stock or members of the managed corporation when a stockholder or stockholders representing the same interest of both the managing and managed corporations own more than 1/3 of the total outstanding capital stock entitled to vote of the managing corporation, or a majority of the members of the BOD of the managing corporation also considered a majority of the BOD of the managed corporation. No management contract shall be entered into for a period longer than 5 years for any one term. 1 to 3 above applies to any contract whereby a corporation undertakes to manage or operate all or substantially all of the business of another corporation, whether such are called service contracts, operating agreements, or otherwise. Service contracts or operating agreements which relate to exploration, development, exploitation, or utilization of natural resources may be entered into for such period as may be provided in the pertinent laws and regulation. Note: 2 general restrictions on the power of the corporation to acquire and hold properties. These are: 1. The property must be reasonably and necessarily required by the business. 2. That the power shall be subject to the limitations prescribed by other special laws and the Constitution. Corporation may not acquire more than 30% of the voting stocks of the bank. Corporations are restricted from acquiring public lands except by lease of not more than 1,000 hectares. Ultravious Act. Ultravious acts are those acts which a corporation is not empowered to do or perform because they are not conferred by its articles of incorporation or by the corporation code, or not necessary or incidental to the exercise of the powers so conferred. Section 45. Types of ultravious acts. 1. Acts done beyond the powers of the corporation as provided in the law or its articles of incorporation. 2. Acts or contracts entered into in behalf of a corporation by persons who have no corporate authority. Note: these are technically ultravious acts of officers and not of the corporation. 3. Acts or contracts which are per se illegal as being contrary to law. Applicability of the ultravious doctrine. It is a question, therefore, in each case of the logical relation of the act to the corporate purpose expressed in the charter. If that act is one which is lawful in itself and not otherwise prohibited, is done for the purpose of serving corporate ends, and is reasonably tributary to the promotion of those ends in a substantial and not in a remote and fanciful sense, it may fairly be considered within the charter powers. The test to be applied is whether the act in question is in direct and immediate furtherance of the corporation's business, fairly incident to the express powers and reasonably necessary to their exercise. If so, the corporation has the power to do it; otherwise, not. Consequences. 1. Executed contract. Courts will not set aside or interfere with such contracts. Executory contracts. No enforcement even at the suit of either party, void and unenforceable. Partly executed and partly executory. Principle of no unjust enrichment at expense of another shall apply. Executory contracts apparently authorized but ultravious, the principle of estoppel shall apply. Ultravious versus illegal acts. Ultravious, not necessarily unlawful but outside the powers of the corporation. It can be ratified, can bind the parties if wholly or partly executed. It's voidable and may be enforced by performance, ratification, or estoppel. If it's illegal act, it is unlawful, it's against the law, morals, public policy, and public order. It cannot be ratified, it cannot bind the parties, and it is void and cannot be validated. Remedies in case of ultravious acts. Remedies by the state. Dissolution of the corporation through a co-warranty proceeding. Injunction. Suspension of or revocation of the certificate of registration by the SEC. By the stockholder. Injunction. Derivative suit. Ratification except when the third party is prejudiced or the act is illegal. By the creditors. Nullification of contract in fraud of creditors. How corporate powers are exercised. By the shareholders. Corporate acts requiring all shareholders' approval. General rule: vote necessary to approve a particular corporate act as provided in this code shall be deemed to refer only to stocks with voting rights. Exception, Section 6. Voting and non-voting shares shall be entitled to vote in the following cases: amendment of articles of incorporation, adoption, amendment, and repeal of bylaws, sale, lease, mortgage, or other disposition of substantially incorporate assets, incurring, creating, or increasing bonded indebtedness, increase or decrease of capital stock, merger and consolidation, investment of funds in another corporation or business or for any purpose other than the primary purpose for which it was organized. Requisites, Section 42. Approval of majority of the BOD or trustee, ratification by the stockholders representing at least two-thirds of the outstanding capital stock or the members at a meeting duly called for the purpose, written notice addressed to each stockholder or member at his place of residence as shown on the books of the corporation, appraisal right available to dissenting stockholders or members, dissolution of the corporation, Section 118 to 121. Corporate acts requiring voting shareholders' approval. 1. Declaration of stock dividends, Section 43. 2. Management contracts, Section 44. Fixing the consideration of no par of shares, Section 62. Fixing the compensation of directors, Section 30. By the Board of Directors. Doctrine of centralized management under Board of Directors and Trustee. By the officers, corporate officers and corporate employee. Under corporate officer, position is provided for in the bylaws or under the corporation code. RTC has jurisdiction in case of labor dispute. For corporate employee, employed through the action of the managing officer of the corporation, NLRC has jurisdiction in case of labor dispute. So who are the corporate officers? President must be a director. Treasurer may or may not be a director, but must be a resident. Secretary need not be a director unless required by the bylaws, but must be a resident and citizen of the Philippines, and other officers as may be provided in the bylaws. Note, any two or more positions may be held concurrently by the same person, except that no one shall act as president and secretary or as president and treasurer at the same time. Conformably with Section 25 of the Corporation Code, a position must be expressly mentioned in the bylaws in order to be considered as a corporate office. Thus, the creation of an office pursuant to or under a bylaw enabling provision is not enough to make a position a corporate office. The first ruling on the matter held that Incur versus Lazama held that the only officers of a corporation were those given that character either by the Corporation Code or by the bylaws. The rest of the corporate officers could be considered only as employees or subordinate officials. Disqualifications, Section 27. Convicted by final judgment of an offense punishable by imprisonment for a period exceeding 6 years. Convicted by final judgment of a violation of the Corporation Code committed within 5 years prior to the date of his election or appointment. This includes violations of rules and regulations issued by the SEC to implement the provisions of the Corporation Code. Authority of corporate officers. A person dealing with a corporate officer is put on inquiry as to the scope of the latter's authority, but an innocent person cannot be prejudiced if he had the right to presume under the circumstances the authority of the acting officers. Doctrine of apparent authority. If a corporation knowingly permits one of its officers or any other agent to act within the scope of an apparent authority, it holds him out to the public as possessing the power to do those acts. The corporation will, as against anyone who has in good faith dealt with it through such agent, be stopped from denying the agent's authority. Trust Fund Doctrine. The trust fund doctrine means that the capital stock, properties, and the other assets of a corporation are regarded as equity in trust for the payment of corporate creditors. Stated simply, the trust fund doctrine states that all funds received by the corporation in payment of the shares of stock shall be held in trust for the corporate creditors and other stockholders of the corporation. Under such doctrine, no funds shall be used to buy back the issued shares of stock except only in instances specifically allowed by the Corporation Code. The subscribed capital is the same amount that can loosely be termed as the trust fund of the corporation. The trust fund doctrine considered this subscribed capital as a trust fund for the payment of the debts of the corporation to which the creditors may look for satisfaction. Until the liquidation of the corporation, no part of the subscribed capital may be returned or released to the stockholder except in the redemption of redeemable shares without violating this principle. These dividends must never impair the subscribed capital. Subscription commitments cannot be condoned or remedied, nor can the corporation buy its own share using the subscribed capital as the consideration therefor. Under Section 43 of the Code, the corporation can declare dividends only out of unrestricted retained earnings, and that under Section 122, no corporation shall distribute any of its assets or property except upon lawful dissolution and after payment of its debts and liabilities. These provisions, in essence, provided for the trust fund doctrine, where the subscription to the capital of a corporation constitute a fund to which creditors have a right to look for satisfaction of their claims. The trust fund doctrine, first enunciated by this court in the 1923 case of Philippine Trust Company versus Rivera, is the underlying principle in the procedure of the distribution of capital asset embodied in the Corporation Code, which allows the distribution of corporate capital only in three instances, which are: 1. Amendment of the Articles of Incorporation to reduce the authorized capital stock; 2. Purchase of redeemable shares by the corporation regardless of the existence of unrestricted return earnings; and 3. Dissolution and eventual liquidation of the corporation. Furthermore, the doctrine is articulated in Section 41 on the power of a corporation to acquire its own shares, and in Section 122 on the prohibition against the distribution of corporate assets and property unless the stringent requirements therefor are complied. The creditors of a corporation have the right to assume that so long as there are debts and liabilities, the BOD will not use corporate assets to purchase its own shares of stock or to declare dividends to its stockholders when the corporation is insolvent. The trust fund doctrine is not limited to reaching the stockholders' unpaid subscriptions. The scope of the doctrine when the corporation is insolvent encompasses not only the capital stock, but also other property and assets generally recorded in equity as a trust fund for the payment of corporate debts. All assets and property belonging to the corporation held in trust for the benefit of creditors that were distributed or in the possession of the stockholders, regardless of full payment of their subscriptions, may be reached by the creditor in satisfaction of its claim. Also, under the trust fund doctrine, a corporation has no legal capacity to release an original subscriber to its capital stock from the obligation of paying for his shares in whole or in part without a valuable consideration or fraudulently to the prejudice of creditors. The creditor is allowed to maintain an action upon any unpaid subscriptions and thereby steps into the shoes of the corporation for the satisfaction of its debt. To make out a prima facie case in a suit against stockholders of an insolvent corporation to compel them to contribute to the payment of its debts by making good unpaid balances upon their subscriptions, it is only necessary to establish that the stockholders have not in good faith paid the par value of the stocks of the corporation. Doctrine of Centralized Management. General rule, unless otherwise provided in this code, the corporate powers of all corporations formed under this code shall be exercised. All business conducted and all property of such corporations controlled and held by the BOD or trustees to be elected from among the holders of stocks, or where there is no stock, from among the members of the corporation, who shall hold office for 1 year until their successors are elected and qualified. Section 23. Exceptions. In case of an executive committee duly authorized in the bylaws. Exception to exception. The following may not be delegated to the executive committee. 1. Approval of any action for which shareholders' approval is also required. 2. The filing of vacancies in the board. 3. The amendment or repeal of bylaws or the adoption of new bylaws. 4. The amendment or repeal of any resolution of the board which, by its expressed terms, is not so amendable or repealable. And 5. A distribution of cash dividends to the shareholder. Section 35. In case of a contracted manager, which may be an individual, a partnership, or another corporation, note, in case the contracted manager is another corporation, the special rule is Section 44. In case of closed corporation, the stockholders may manage the business of the corporation rather than the BOD, if the Articles of Incorporation so provide. Section 97. The power to purchase real property is vested in the BOD or trustees, while a corporation may appoint agents to negotiate for the purchase of real property needed by the corporation. the final say will have to be with the board, whose approval will finalize the transaction. Indisputably, one of the rights of a stockholder is the right to participate in the control or management of the corporation. This is exercised through his vote in the election of directors because it is the BOD that controls or manages the corporation. Requisites of a valid corporate act by the BOD. The board must act as a body in a meeting. There must be a validly constituted meetings. Their act must be supported by a majority of the quorum duly assembled. Exception: election of officers requires a vote of majority of all the members of the board. D. The act must be within the powers conferred to the board. Limitations on powers of the BOD. Limitations or the Board of Trustees. Limitations imposed by the Constitution, statutes, articles of incorporation, or bylaws. Certain acts of the corporation that require joint action of the stockholders and the BOD. Removal of director, Section 28. Amendment of Articles of Incorporation, Section 16. Fundamental changes, Section 6. Declaration of stock dividends, Section 43. Entering into management contracts, Section 44. Fixing of consideration of non-par shares, Section 62. Fixing of compensation of directors, Section 13. Cannot exercise powers not possessed by the corporation. Principle on delegation of board power. Section 23. The power and the responsibility to decide whether the corporation should enter into a contract that will bind the corporation is lodged in the board, subject to the articles of incorporation, bylaws, or relevant provisions of law. However, just as a natural person may authorize another to do certain acts for and on his behalf, the BOD may validly delegate some of its functions and powers to officers, committees, or agents. The authority of such individuals to bind the corporation is generally derived from law, corporate bylaws, or authorization from the board, either expressly or impliedly by habit, custom, or acquiescence in the general course of business. Business judgment rule. General rule: directors cannot be held liable for mistakes or errors in the exercise of their business judgment as long as they acted in good faith, with due care and prudence. Contracts entered into by the BOD are binding upon the corporation, and courts will not interfere. Exception: if the contracts are so unconscionable and oppressive as to amount to a wanton destruction of the rights of the minority. If they violate their duties under Section 31, director willfully and knowingly assents to patently unlawful acts of the corporation, or are guilty of gross negligence or bad faith, and C. If they violate Section 34, disloyalty of a director who acquires for himself a business opportunity that should have belonged to the corporation unless his act is ratified by a two-thirds vote of stockholders. Consequences of the business judgment rule. The resolution, contracts, and transactions of the board cannot be overturned or set aside by the stockholders or members, and not even by the courts, under the principle that the business of the corporation has been left to the hands of the board. Directors and duly authorized officers cannot be held personally liable for acts or contracts done with the exercise of their business judgment. Exceptions: when the corporation code expressly provides otherwise. When the directors or officers acted with fraud, gross negligence, or in bad faith. Section 31. When directors or officers act against the corporation in conflict of interest situation. Remedies in case of mismanagement. Removal of directors pursuant to Section 28. Derivative suit or complaint filed with the RTC. Receivership. Injunction if the acts has not yet been done. Dissolution if abuse amounts to a ground for quo warranto but Solicitor General refuses to act. Note: Dean Villanueva opined that a derivative suit may be an exception to such rule. This occurs when it is apparent that the board is not in a position to validly exercise its business judgment for the protection of the corporation, that is, when the board itself has committed an act causing damage to the corporation or when the board is placed in a conflict of interest scenario whereby it is unlikely that it would use such business discretion to file such suit for the best interest of the corporation. Tenure. Directors shall hold office for 1 year until their successors are elected and qualified. Term versus tenure. Term is the time during which the officer may claim to hold the office as of right and fixes the interval after which the several incumbents shall succeed one another. It is not affected by the holdover. It is fixed by statute and it does not change simply because the office may have become vacant, nor because the incumbent holds over in office beyond the end of the term due to the fact that a successor has not been elected and has failed to qualify. The term is 1 year. Under tenure, the period within which the director actually holds office, including the holdover period after the end of his term. It includes holdover, and it may be shorter or longer in case of a holdover than the term for reasons within or beyond the power of the incumbent. Qualifications. If stock, director must own at least 1 share of the capital stock, which stock shall stand in his own name. Exception, trustee in a voting trust may be elected director or trustee. If non-stock, trustee must be a member. Qualifications, majority of the director or trustees must be residents of the Philippines, natural person, of legal age, other qualifications as may be prescribed in the bylaws of the corporation. With the omission of the phrase in his own right, the election of trustees and other persons who in fact are not beneficial owners of the shares registered in their name on the books of the corporation becomes formally legalized. Hence, this is a clear indication that in order to be eligible as a director, what is material is the legal title to, not beneficial ownership of, the stock as appearing on the books of the corporation. Disqualification, Section 27. Convicted by final judgment of an offense punishable by imprisonment for a period exceeding 6 years, or a violation of the Corporation Code committed within 5 years prior to the date of his election. This includes violations of rules and regulations issued by the SEC to implement the provisions of the Corporation Code. An amendment to the corporation's bylaws which renders a stockholder ineligible to be a director if he be also a director in a corporation whose business is in completion with that of the other corporation, has been sustained as valid. This is based upon the principle that where the director is so employed in the service of a rival company, he cannot serve both, but must betray one or the other. Such an amendment advances the benefit of the corporation and is good. Election. Cumulative voting. Cumulative voting for one candidate. A stockholder is allowed to concentrate his votes and give one candidate as many votes as the number of directors to be elected multiplied by the number of his shares shall equal. Illustration, if there are 5 directors to be elected and Pedro, as a shareholder, has 100 shares, Pedro can give 500 or 5 times 100 shares vote to just one candidate. Cumulative voting by distribution. A stockholder may cumulate his shares by multiplying the number of his shares by the number of directors to be elected and distribute the same among as many candidates as he shall see fit. Illustration, if the illustration above, Pedro instead may choose to give 100 votes to candidate 1, 100 to candidate 2, 100 to candidate 3, 150 votes for candidate 4, and 50 votes to candidate 5. Straight voting. Every stockholder may vote such number of shares as many persons as there are directors to be elected. Quorum. There must be present in person or by representative authorized to act by written proxy the owners of majority of the outstanding capital stock or OCS, or a majority of the members entitled to vote in the meeting. Election must be by ballot if requested. A stockholder cannot be deprived in the Articles of Incorporation or in the bylaws of his statutory right to use any of the methods of voting in the election of directors. No delinquent stock shall be voted. The candidates receiving the highest number of votes shall be declared elected. Removal. General rule: any director or trustee of a corporation may be removed from office, with or without cause. Exception: directors who have been elected by minority stockholders exercising cumulative voting can only be removed for cause. Removal without cause may not be used to deprive minority stockholder or members of the right of representation to which they may be entitled under Section 24. Other requisites: by a vote of the stockholders holding or representing two-thirds of the outstanding capital stock, or if the corporation be a non-stock corporation, by a vote of two-thirds of the members entitled to vote at a regular or special meeting after proper notice is given. Fiduciary duties and liability rules. Duties. In this jurisdiction, the member of the BOD have a threefold duty: duty of obedience, duty of diligence, and duty of loyalty. Duty of obedience shall direct the affairs of the corporation only in accordance with the purposes for which it was organized. Duty of diligence shall not willfully and knowingly vote for or assent to patently unlawful acts of the corporation, or act in bad faith or with gross negligence in directing the affairs of the corporation. And duty of loyalty shall not acquire any personal or pecuniary interest in conflict with their duty as such directors or trustees. In duty of obedience, the directors of trustees and officers to be elected shall perform the duties enjoined on them by law and by the bylaws of the corporation. Under the duty of diligence, directors or trustees who: 1. Willfully and knowingly vote for or assent to patently unlawful acts of the corporation, or who are guilty of gross negligence or bad faith in directing the affairs of the corporation, or acquire any personal or pecuniary interest in conflict with their duty as such director or trustees, shall be liable jointly and severally for all damages resulting therefrom, suffered by the corporation, its stockholders or members, and other persons. That's Section 31. The conditions for the application of Section 31 of the Corporation Code require factual foundations to be first laid out in appropriate judicial proceedings. Hence, concluding that a person breached fiduciary duties as an officer and member of the BOD of a corporation without competent evidence thereon would be unwarranted and unreasonable. For duty of loyalty, directors and trustees should not acquire any personal or pecuniary interest in conflict with their duty as such director or trustees, otherwise they shall be held liable jointly and severally for all damages resulting therefrom, suffered by the corporation, its stockholders or members, and other persons. Where a director by virtue of his office acquires for himself a business opportunity which should belong to the corporation, thereby obtaining profits to the prejudice of such corporation, he must account to the latter for all such profits by refunding the same, unless his act has been ratified by a vote of the stockholders owning or representing at least two-thirds of the outstanding capital stock. Section 34. Doctrine of corporate opportunity. Unless his act is ratified, a director shall refund to the corporation all the profits he realizes on a business opportunity which 1. Corporation is financially able to undertake. 2. From its nature, it is in line with corporation's business and is of practical advantage to it. And 3. One of which the corporation has an interest or a reasonable expectancy. The rule shall be applied notwithstanding the fact that the director risked his own funds in the venture. By embracing the opportunity, the self-interest of the officer or director will be brought into conflict with that of his corporation. Hence, the law does not permit him to seize the opportunity even if he will use his own funds in the venture. Sundyang and Aquino. Note differences between Section 31 and Section 34. First, while both involve the same subject matter, business opportunity, They concern different personalities. Section 34 is applicable only to directors and not to officers, whereas Section 31 applies to directors, trustees, and officers. Second, Section 34 allows a ratification of a transaction by a self-dealing director by vote of stockholders representing at least two-thirds of the outstanding capital stock. Liabilities. Solidary liability for damages, willfully and knowingly voting for and assenting to patently unlawful acts of the corporation, gross negligence or bad faith in directing the affairs of the corporation, acquiring any personal or pecuniary interest in conflict of duty, consenting to the issuance of watered stocks or having knowledge thereof, failing to file objections with the secretary, agreeing or stipulating in a contract to hold himself liable with the corporation or by virtue of a specific provision of law. Liability for watered stock. What is watered stock? Stocks issued for consideration less than its par or issued value, or for consideration in any form other than cash, value in excess of its fair value. Any director or officer of a corporation consenting to the issuance of a watered stock or who, having knowledge thereof, does not forthwith express his objection in writing and file the same with the corporate secretary, shall be solidarily liable with the stockholder concerned to the corporation and its creditors for the differences in value. Personal liability general rule. Members of the board who purport to act in good faith for and on behalf of the corporation within the lawful scope of their authority are not liable for the consequences of their acts, while the acts are of such nature and done under those circumstances, they are attributed to the corporation alone and no personal liability is incurred. The provisions on seizing corporate opportunity and disloyalty, Section 31 and 34, shall also apply to corporate officers. Note, members of the BOD who are also officers are held to a more stringent liability because they are in charge of day-to-day activities. Doctrine of limited liability and doctrine of immunity. Under the doctrine of limited liability, it shields the incorporators from corporate liability beyond their agreed contribution to the capital or shareholding in the corporation. Under doctrine of immunity, it protects a person acting for and in behalf of the corporation from being himself personally liable for his authorized actions. Liability of director, trustee, or officer. Personal liability of a corporate director, trustee, or officer, along, although not necessarily with the corporation, may so validly attach as a rule only when 1. He assents to a patently unlawful act of the corporation, or for bad faith or gross negligence in directing its affairs, or C. for conflict of interest resulting in damages to the corporation, its stockholders, or other persons. When he consents to the issuance of watered stock, or who, having knowledge thereof, does not forthwith file with the corporate secretary his written objection thereto, and when he agrees to hold himself personally and solidarily liable with the corporation, and when he is made, by specific provision of law, to personally answer for his corporate action. General rule majority view. Directors only owe its duty to the corporation. They owe no fiduciary duty to stockholders, but they may deal with each other at fair and reasonable terms as if they were unrelated. No duty to disclose facts known to the director or officer. Note, minority view, realistic way, recognizes the director's obligation to the stockholders individually as well as collectively, and refuses to permit him to profit at the latter's expense by the use of information obtained as a result of official position and duties. Exception, special facts doctrine, conceding the absence of a fiduciary relationship. In the ordinary case, courts nevertheless hold that where special circumstances or facts are present which make it inequitable for the director to withhold information from the stockholder, the duty to disclose arises and concealment is fraud, such as concealment of the defendant purchaser's identity. The corporate officer had used an agent go-between to avoid detection of his actions by the seller here, and a failure to disclose significant facts that materially affected the price of the stock. Responsibility for crimes. Since a corporation as a person is a mere legal fiction, it cannot be proceeded against criminally because it cannot commit a crime in which personal violence or malicious intent is required. Criminal action is limited to the corporate agents guilty of an act amounting to a crime and never against the corporation itself. Since the BOD is the repository of corporate powers and acts as the agent of the corporation, the directors may be held criminally liable. The trust receipts law recognizes the impossibility of imposing the penalty of imprisonment on a corporation. Hence, if the entrustee is a corporation, the law makes the officers or employees or other persons responsible for the offense liable to suffer the penalty of imprisonment. The reason is obvious. Corporations, partnership, associations, and other juridical entities cannot be put to jail. Hence, the criminal liability falls on the human agent responsible for the violation of the trust receipts law. Inside information. The fiduciary position of insiders, directors, and officers prohibits them from using confidential information relating to the business of the corporation to benefit themselves of any competitor corporation in which they may have a mere substantial interest. Since loss and prejudice to the corporation is not a requirement for liability, the corporation has a cause of action as long as there is unfair use of inside information. It is inside information if it is not generally available to others and is acquired because of the close relationship of the director or officer to the corporation. An insider means the issuer, B, a director or officer or any person performing similar functions of or person controlling the issuer gives or gave him access to material information about the issuer or the security that is not generally available to the public. C, a government employee, director, or officer of an exchange, clearing agency and or self-regulatory organization who has access to material information about an issuer or a security that is not generally available to the public, or a person who learned such information by communication from any foregoing insiders. Contracts. Self-dealing directors with the corporation. General rule, a contract of the corporation with one or more of its directors or trustees is voidable at the option of such corporation. Exception, such contract is valid if all of the following conditions are present: that the presence of such director or trustee in the board meeting in which the contract was approved was not necessary to constitute a quorum for such meeting, that the vote of such director or trustee was not necessary for the approval of the contract, that the contract is fair and reasonable under the circumstances, and that in case of an officer, the contract has been previously authorized by the BOD. Ratification in case of absence of the first two conditions above. Contract may be ratified if stockholders representing at least two-thirds of the outstanding capital stock or at least two-thirds of the members in a meeting called for the purpose voted to ratify the contract. Full disclosure of the adverse interests of the directors or trustees involved is made at such meeting. Contract is fair and reasonable under the circumstances. Between corporations with interlocking directors. General rule. A contract between two or more corporations having interlocking directors shall not be invalidated on that ground alone. Section 33. Exception if contract is fraudulent or not fair and reasonable under the circumstances. Interlocking characterized. If the interests of the interlocking director in the corporations are both substantial, like stock holdings exceed 20% of outstanding capital stock, Section 33, and that is an interlocking director. Interlocking director with nominal and substantial interest. If the interest of the interlocking director is one of the corporation is nominal stock holdings 20% or less, while substantial in the other, the contract shall be valid if the following conditions are met: The presence of such director or trustee in the board meeting in which the contract was approved was not necessary to constitute a quorum for such meeting. That the vote of such director or trustee was not necessary for the approval of the contract. That the contract is fair and reasonable under the circumstances. Where A, B are absent, the contract can be ratified by the vote of the stockholders representing at least two-thirds of the outstanding capital stock, or at least two-thirds of the members in the meeting called for the purpose voted to ratify the contract, provided that full disclosure of the adverse interest of the director or trustees involved is made on such meeting, and the contract is fair and reasonable under the circumstances. Executive Committee, Section 35, Creation. The bylaws of a corporation may create an executive committee composed of not less than 3 members of the board to be appointed by the board. Said committee may act by majority vote of its members on such specific matter within the competence of the board, as may be delegated to it in the bylaws or on a majority vote of the board. Limitations on its power. The following cannot be delegated. 1. Matters needing stockholders' approval. Filling up of board vacancies. Amendment, repeal, or adoption of bylaws. Number 4. Amendment or repeal of any resolution of the board which, by its express terms, is not amendable or repealable. Number 5. Cash dividend distribution. 6. Acts which would render the BOD powerless and free from all responsibilities imposed on it by law. Under Section 35 of the Corporation Code, the creation of an executive committee must be provided for in the bylaws of the corporation. Unfortunately, the bylaws of the corporation in this case are silent as to the creation of its BOD of an executive committee. Notwithstanding the silence of the bylaws on the matter, the Supreme Court did not rule that the BOD's creation of the executive committee is illegal or unlawful. One reason is the absence of a showing as to the true nature and functions of said executive committee, considering that the executive committee referred to in Section 35 of the Corporation Code, which is as powerful as the BOD, and in effect acting for the board itself, should be distinguished from other committees which are within the competency of the board to create at any time and whose actions require ratification and confirmation by the board. Another reason is that the BOD has the power to create positions not provided for in the bylaws, since the board is the corporation's governing body. Meetings, regular or special, and who may attend, the members of the board themselves, directors or trustees, cannot be represented or voted by proxies at board meetings. In the Philippines, teleconferencing and video conferencing of members of BOD of private corporation is a reality in light of Republic Act number 8792. The Securities and Exchange Commission issued SEC Memorandum Circular number 15 series of 2001 on November 30, 2001, providing the guidelines to be complied with in relation to such conferences. When and where? Regular meetings of directors or trustees shall be held monthly unless the bylaws provide otherwise. Special meetings of the BOD or trustees may be held at any time upon the call of the president or as provided in the bylaws. Where? Meetings of directors or trustees of corporations may be held anywhere in or outside of the Philippines unless the bylaws provide otherwise. Notice of regular or special meetings stating the date, time, and place of the meeting must be sent to every director or trustee at least 1 day prior to the scheduled meeting unless otherwise provided by the bylaws. A director or trustee may waive this requirement either expressly or impliedly. Section 50. Who presides? The president presides unless the bylaws provide otherwise. And for the quorum, general rule, majority of the member of directors or trustees as fixed in the Articles of Incorporation, Section 25. Exception unless the Articles of Incorporation or the bylaws provide for a greater majority, or in case of election of officers where a vote of a majority of all the members of the board is needed. For stock corporations, whether or not dead members are entitled to exercise their voting rights through their executor or administrator depends on the articles of incorporation or bylaws. For a non-stock corporation, only those who are actual living members with voting rights shall be counted in determining the existence of a quorum during member meetings. Dead members shall not be counted. The quorum in a members' meeting is to be reckoned as the actual number of members of the corporation. In the event of death of one of the shareholders in stock corporation, shareholders may generally transfer their shares. Thus, on the death of a shareholder, the executor or administrator duly appointed by the court is vested with the legal title to the stock and entitled to vote it. Until a settlement and division of the estate is effected, the stocks of the decedent are held by the administrator or executor. On the other hand, membership in all rights arising from a non-stock corporation are personal and non-transferable, unless the articles of incorporation or the bylaws of the corporation provide otherwise. In other words, the determination of whether or not dead members are entitled to exercise their voting rights through their executor or administrator depends on the articles of incorporation or the bylaws. Rule on abstention. A vote of abstention is considered to be a vote in itself. Abstentions will not be counted towards the affirmation or the affirmative, and such refusal to vote does not by itself indicate acquiescence in the action of those who vote. A presumption of intent behind the abstention is only prima facie. Thus, an inquiry into the facts and circumstances attending the voting is necessary. So, regular meeting held monthly unless the bylaws provide otherwise, special at any time upon the call of the president or as provided in the bylaws.